Hello, my name is Paul Meinrich. I am a family law attorney in Santa Ana, Orange County, California. I have been in practice for just over 37 years, and most of that time, at least since the late 1980s, I've been specializing in doing family law cases. I have done a number of other things prior to that time, but since the late 80s, I've been concentrating on family law. My practice is again primarily devoted to that, and I am a state certified family law specialist. I'm certified by the State Bar of California. I'd like to use this video as an opportunity to introduce myself and to discuss the issue of pensions as a means of doing that, so you can see how I am and see if you may get along with me, because that's important if you choose a family law attorney, that you're going to be able to get along with that attorney. So let's talk a little bit about pensions and what they are and how they're divided in a family law case. Generally speaking, most people know what they have as far as a pension plan or not. They at least know that they're in a pension plan. But there's two basic types. One is called a defined benefit pension plan. The other is called a defined contribution pension plan. A defined benefit pension plan used to be very common. It's the type of plan that says, when I reach a certain age, having worked for a company for a certain amount of years, I will be entitled to X amount of dollars per month for the rest of my life. Those kind of plans are far less common now. They're usually just government pension plans like CalPERS or CalSTRS. There are some private plans for the Teamsters and the Food Workers Union that still maintains defined benefit plans. The other type of plan is a defined contribution plan. A defined contribution plan is basically a savings account type of a plan, a profit sharing or a 401k. Those are good examples of a defined contribution plan. The way that you deal with these plans in a divorce case is, first you have to characterize the plan as to whether it's community or separate. If a portion of it accrued during the time either before marriage or after separation, which is most of the time, there's going to be aspects of both community and separate property to both of those kinds of plans. In a defined benefit plan, the way that you apportion the separate and community interests is basically twofold. One is the time rule formula. It's a fraction, the numerator of which is the time that was put in by the working spouse either before marriage or after separation. And the bottom portion of it is the total time that the person has been in the plan. That fraction will then tell you the separate property component of the defined benefit plan. The other way to do it is perhaps more simply, is you take the years of the community, the years of marriage, use that as the numerator of the fraction, and then you wait until the person retires, and the total amount of years and months that they have in the plan would be the denominator of the fraction. That then, if you multiply it times the benefit that the person gets, it gives you your community share, which is then split between the parties. That's the time rule formula. That's traditionally the way that those are divided. The other way is you can actuarially determine the present value of a plan that says, if I pay you X amount of dollars from the time you retire until the time you die, how much do I need today in order to fund that stream of payments? An actuary can tell you that information, and you can get a lump sum. The trouble with it is sometimes that lump sum is so large that there's not another asset by which to offset it in a divorce case. So you simply have to then wait until the person retires, and you divide each payment as it comes in. A defined contribution plan is one where you determine what was in the plan before marriage and what has been put in after separation, and then you determine what's left is the community. Sometimes it's a little more difficult than that, to the extent that if a person has been married a long time but they were working before marriage, you've got to take that date of marriage balance and figure what that is worth today and back that out of the present value of the plan in order to come up with what the community portion is worth. So there's some mathematics and some arithmetic involved with it, but it can be fairly logical and straightforward if you think about it in the right way. The plans are divided by what's called a quadro, generally speaking, Qualified Domestic Relations Order. That's applicable to private pension plans, and it's required by the federal law to have a Qualified Domestic Relations Order in order for a state court to divide that pension benefits that's otherwise controlled by federal law. You've got to have the kind of order that the federal law requires. And a government plan that's not governed by the federal law, such as a CalSTRS plan or a PERS plan, a government plan, you don't need a quadro, you just need a DRO, or a Domestic Relations Order. And it basically accomplishes the same thing. So those are the things that you need in order to divide a pension plan. A couple of little points that come up is sometimes parties need to choose what kind of payment they're going to get from that defined benefit plan. And the phrase joint survivor annuity comes into play. Sometimes the ex-spouse can be given a pension that will last after the death of the participant employee spouse, and that can be worked into the pension plan. The defined contribution plan is basically divided then and there. The money is rolled over into an account in the spouse's name, and that's then controlled by that spouse, and it's a done deal. So those are a few points with regard to pension plans and how they're divided. If you have questions about it, I have some information on my website, and if you want to speak with me personally about it, more than happy to do so. Free initial consultation, give me a call. I can tell you what I can and can't do, and we can develop a game plan for your case. Thank you very much.